Hello and welcome back to Freedom Matters. I'm your host, Mark McIntire. And I have a very special premium program for you today because I got to spend the entire day out at the Ronald Reagan Presidential Library and Museum in Simi Valley. If you haven't been there, please treat yourself. You'll love it. But I wasn't there to just look at the 747 hanging from the ceiling, Air Force One. No, I was there to interview Mr. Mark Mix. Now, Mark Mix is the president both of the National Right to Work Legal Defense Foundation and the National Right to Work Committee. These two organizations, for the last 60 years, have guided 27 states to become right to work states. Now, what does that mean? Well, if you live in any one of these 27 states, what this means is you are not compelled to join a labor union in order to get or keep your job. Even better, you are not compelled to see your compulsory dues fly off to some politician, political campaign, or cause with which you disagree in conscience. Right to work is an individual freedom issue. Now, you'll also see, after the interview with Mark Mix, you'll see a very brief encounter with a friend of mine, Congressman Tom McClintock, who represents the 4th Congressional District here in California. I know, Republican congressman from California, right? I get it. You know, Tom is not very popular even with the Republican National Committee. As a matter of fact, he told me yesterday that he didn't get a single dime in 2016, and yet he won anyway against a very strong liberal, progressive Democrat candidate. And the reason why Tom is deserving of the Senator Everett Dirksen Award given by the National Right to Work Legal Defense Foundation this year is because he is a defender of individual freedom in the Bill of Rights and in the entire Constitution. That's his dedication. And he certainly has earned the respect of his constituency. Republicans, Democrats, Libertarians, even some socialists agree that he is a man of integrity. In the tape you'll see, he's agreed to be a featured guest here on Freedom Matters, and we will bring that to you as soon as Alex Madagian, our talent coordinator, sets it up with Jennifer up at Tom McClintock's office in Washington, D.C. Now, the third tape you're going to see is actually a throwback to 1986 when I was on the Screen Actors Guild Board of Directors. I was elected to a 3-year position. I was sponsored by Charlton Heston, and I began working with him. And Right to Work is contagious because working with Chuck, there were two things Chuck would really get excited about and go campaigning for. Naturally, one was the Second Amendment because he was the president of the National Rifle Association. But as a former president of Screen Actors Guild 6 times, he also had a dedication to right to work legislation. So I would actually go with him out on some of these campaign expeditions, and it was a wonderful thing to fly into a state, meet with legislators and the governors, and see Charlton Heston work his magic on convincing people that right to work is an individual freedom matter. So you'll get to see that. In any case, I want you to know that we appreciate here at Freedom Matters all the support that you give us, because without it, we couldn't continue to do what we do. I just want to say thank you. And now, please enjoy the rest of the show. Hello, I'm Mark McIntire, your host for Freedom Matters. Welcome back. Well, today I'm at the Ronald Reagan Library and Museum in Simi Valley. I'm here to interview Mr. Mark Mix. Mark Mix is the president of the National Right to Work Committee and the National Right to Work Legal Defense Foundation. Over the last 60 years, these two organizations have guided 25 of the 50 states to become right to work states. What does that mean? Well, if you live in a right to work state, you don't have to join a labor union in order to get or keep your job. And you don't have to have your compulsory dues sent to campaigns, causes, and issues with which you said you have disagreed. So in a minute, we'll step inside, look at the beautiful interior. It's a 747 hanging from the ceiling. You don't see that every day. And we'll begin our interview with Mr. Mark Mix. So stay with us and enjoy.
That was the visual I wanted to create.
All right, so here we are, and we are with Mark Mix, who is the president of both the National Right to Work Committee and the National Right to Work Legal Defense Fund. It's good to see you again.
Oh, Mark.
It's been a lot of years.
Yeah, pleasure to see you. You've been a champion in this fight for a long time, and thank you for that.
Well, I appreciate it because I've started this new program. It's called Freedom Matters, and we're all about drilling down for the public into the basic core principles and values that individuals have concerning their concepts of freedom. Yeah. And I can't think of a better guest than to have you on today for the work that the committee and the foundation has been doing for the last, about 60 years, guiding us through various Supreme Court cases, state court cases, even local cases. Without what the foundation and the committee has been doing, 25 states would not be now a right to work states. Is it 25?
It's 27 now, Mark. We've made great progress. See, you've been in the fight a long time.
You see how old I am, folks? I mean, this must have happened last night when I was asleep.
It's been 5 in the last 7 years, so It's been exciting.
Wow.
Yeah.
Do you know how many there were when I was on the Screen Actors Guild Board of Directors?
I don't even want to guess.
22.
Yeah. Idaho. Well, you were involved in the Idaho fight, and that was the 22nd, I believe,
yes,
right?
Yes. And then the New Mexico fight.
Yep. Well, the New Mexico fight didn't go as well as the Idaho fight.
Well, we were ambushed.
That's right.
We were ambushed.
That's right. You were there with Charlton Heston.
Chuck was pretty mad.
Yeah. I remember because his plane was inbound when the bill was introduced, and the Speaker of the House assigned it to 4 committees, remember? And then they passed a law that said we could never bring it up again when Heston, before he even got on the ground. And that made him a little bit mad.
It did. And a man named Richardson was the person who put the poison in the well.
Yeah. Yeah,
and he later became something in the Clinton administration, didn't he?
Secretary of something?
Yeah,
yes,
Secretary of something. Yeah, Secretary of something.
Secretary of something.
He'll go down in history as Secretary of something. Well, anyway, we always start our show, Mark, with asking our guests to share with our audience your basic principles of human freedom, the values, and how you got those. I'm going to let you go on that.
Well, first of all, the good news is right to work is very simple. So I don't bring a great intellectual toolbox to this fight because it's a really basic issue of freedom. But then, to your point, Mark, and to the focus of the show, the idea of individual freedom is a very, very important issue, and it goes to the very founding of our country. I mean, the idea of this great experiment in self-government is predicated on our responsibilities as individuals to be participants in our government, but also it is our responsibility to protect ourselves from a government that would overreach, and certainly the Bill of Rights was a function of that. I think studying those great documents, although I won't say that I was a great student of them back in high school and growing up, I cared more about baseball and wrestling and girls than that. But I will tell you this: I had a high school professor who taught social studies and civics, and he was an extreme liberal, Mark. He was really over-the-top leftist. I mean, he would be great with this group of Democrat candidates that are running for president right now. But I didn't know. I really didn't know. You know, I hadn't sorted out at that point in time about what these issues meant. And he led me down this road. He got me to register as a Democrat. He got me to bartender at his political events at his home and these types of things for candidates that now I look back and I'm trying not to tell anyone who those candidates were. But anyway.
Date yourself, actually.
Yeah, right. Well, and then I got to college and I had a great friend that handed me a book. You know what book that was? It was Atlas Shrugged. It was the Objectivist novel. And
I read.
Yeah. And so I read that, and that kind of focused my thoughts on individual freedom. And while I disagree with her atheistic positions, I believe there is a creator God and he really kind of is a plan. But I think living our lives in a way that we earn things and that we value human productivity and human understanding and human liberty, most importantly, were fundamental principles. And then I kind of added a little dose of Frederick Bastiat and the law, and his ideas. He has his really simple ideas about what's theft, and then it kind of culminated in the ability to work for right to work. It came out of I graduated from college, I needed work, and a friend of mine called me and said, "Hey, you want to work on a congressional campaign?" I did. We won the campaign, and then I got a call from this organization called Right to Work that I really didn't know much about, and kind of the rest is history. I grew up in a union household. My stepfather was a welder, as a machinist union member. Yep. Wow. My mom worked in a school cafeteria. She washed dishes. She was a member of the union there. To this day, my brother is a school teacher in New York State, 4th grade, and he doesn't have to pay any dues anymore.
No.
We're going to get into that. He used to. Good. Yeah. Right. But that's kind of a basis for where I've gotten. And actually, when you think about the issue of right to work, and you think about the simplicity of it, it is really just simple. I mean,
I know. My grandfather, I have a similar story
Yeah.
to yours. I first became aware of fundamental rights when I was playing chess with my grandfather when I was 12.
Okay.
And he was a multimillionaire when people were jumping out of buildings in 1929.
Mm-hmm.
And I asked him one day, because we were listening to the Democrat convention, I forget where it was, in 1952, and Adlai E. Stevenson was being. And I kept hearing these words, freedom and rights, and then liberal and then conservative. And I said to him, I said, Grandpa, what is a liberal? I'm 12, I don't know what a liberal is. And I hear this word conservative. I don't know what this means. He said, let me tell you. He said, a conservative is a person who puts their money where their mouth is. And a liberal is somebody who puts your money where their mouth is. And to me, that's the easiest way I use to explain right to work. Because it's your money. Right. It's your paycheck. It's your compulsory dues that are going. So I'm glad to hear that you have a philosopher in your background, Ayn Rand, who I call her the Jordan Peterson, the female Jordan Peterson of her day, right?
Yeah.
Because it focuses on the individual.
Yeah.
All rights are individual. They're not group rights. We don't have group rights.
Right.
They're all individual. Good. So now, explain to us, once you joined the Right to Work movement as a professional individual, walk us through the highlight court cases, if you would, be so kind, because you know all of them. I don't know if you want to go back as far as Abood versus Board of Education or not, but if you could just walk us through, and this is, folks, this is just fascinating to see what a foundation can do with contributions, voluntary contributions, to guide states along to individual freedom.
Well, Mark, you played a role in a little bit of this too as we walked through, and I think it's important to start with Abood because that was the fundamental case where we challenged this constitutional issue of whether or not a union could compel someone to pay them a fee to work. And in Abood, in 1977, Louis Abood, a teacher in the Detroit school system, basically said, my political dues are being spent the ways I don't want them, but yet I'm required to pay them. So Abood, actually, people talk about it as a loss, but really Abood was kind of like Beck, and we'll get into that one too, but it split the baby. It said, we can't force you to pay for this political or ideological work that the union's doing, but we can force you to pay for everything else. And of course, as soon as that we got ruined, the union said, well, everything else is everything else. And so, we had one
they
case.
Redefine what everything
exactly.
else is. Yeah, okay.
They had one set of books before we litigated Abood, and then immediately after Abood, they came like a regular business. They had two sets of books, one for the public and one for the operating machine. Right. So they kind of claimed everything to be political. So that journey started with the Abood case in 1977. Then we moved on, and we talked about this injustice of what the unions could spend. And we had a Hudson case, and the Hudson case came in and started laying some of the groundwork for how they were spending the money and what they were doing with it and what could be chargeable and non-chargeable. And we keep moving along the continuum, and we get to 1988, and we have the Beck case. And the Beck case is the private sector kind of twin to the Abood case. Harry Beck, who was a telephone lineman in La Plata, Maryland, found out that his money was being used for something he disagreed with.
80% of his dues dollars.
You remember well. Actually, the special master
I'll
said
never forget
81%.
Oh,
81%.
Oh,
Yeah,
sorry.
81. That's okay. Yeah.
I'll never forget that figure.
Right.
That drove me crazy. When I told that to Charlton Heston, he said, what?
Yeah.
He said, we have to do something about this.
The special master investigating the expenditures of those monies by the Communication Workers of America could only find 19 cents on every dollar that was being used for anything that resembled bargaining.
Contract enforcement.
Right.
Oh,
everything else, and that was an outrageous revelation, if you will, and it spurred us on, and we ended up in the U.S. Supreme Court with the Beck versus CWA case, and we won that case. And again, that was kind of this. Yeah, we understand that this notion of labor peace was very important to the courts. The unions, if we did anything to disturb their compulsory unions in power, it would cause great unrest in the labor markets. And so they used this labor peace argument, but they did segregate the political funds. And that's where you got involved, and Charlton Heston got involved, and lots of other folks got involved in kind of barnstorm.
You know who dragged us in was Bill Buckley.
Right.
Now,
we had the Buckley case too. Right.
Would you explain the Buckley case? I love the Buckley case. In fact, the opening music that we use for this show, when you see the tape, it's the same music that he had.
Yeah.
Right?
Well, Buckley was doing television work, right?
Yeah.
He was doing his show, and
he
was right
after
after
American Federation of Television and Radio Artists.
Yeah.
Okay.
And the last person that I would want to compel to pay dues or fees in addition to doing a job would be Bill Buckley, because not only could he defeat you in a debate, but he could wrap circles around you.
You don't want to compel him to do anything.
I used to have a dictionary to listen to him because every third word was something that I had to look up.
Yeah.
But it was it was another fundamental case.
But he won that case.
Yeah, he won the case, and
they became they were called Buckley members.
Members,
people who followed his footsteps.
Right.
And anybody could do it. The amazing thing to us was that after the Buckley case, any member of the Screen Actors Guild or AFTRA or Equity or the trade unions, IATSE, they could become Buckley members, but they didn't know about it except for the foundation.
Yeah.
And except for the committee.
Right, that's right. And we continue to get the word out. But those were kind of mile markers on the road. Yep. But here's what happened when Charlton Heston got into the game. The Beck decision became a big deal. And you were in Idaho with him, you were in New Mexico with him, you traveled the country with him, and I know you had a financial core group that you set up and you kind of tried to make sure people knew about what their rights were.
Yep.
And really fundamentally that's the issue. I mean, every organization, every battle comes with a requirement for time, talent, and treasure. Mm-hmm. And if you miss one of those elements, it's hard first of all to sustain a program, but it's hard to expand it. And at the foundation we've always had limited resources. Mark, organized labor is a $20 billion a year business. The National Right to Work Foundation will raise roughly between $6 and $10 million a year. I think we go pretty well toe-to-toe with them. But, yeah. So
it's a David and Goliath story.
Yeah. So then we get back in 88, and then we keep moving along the continuum, always trying to get back to that fundamental First Amendment question of this idea of forcing someone to pay a private organization for the privilege of working is a violation of the First Amendment.
Individual freedom.
Yeah. So we get to a case called Leonard in 2007, another case, public sector case that moves along the way, or 2000, I guess Davenport was 2009. We had a case out of Washington State that went to the Supreme Court. And that was a question of whether or not unions had a constitutional claim to people's money. Yeah. And we won that case 9-0. And then we move into California in 2012, a case called Knox, which you, Tom McClintock, helped. And you remember the Knox case?
Yeah, Tom McClintock was very instrumental in it.
Yeah, and we had this where Governor Schwarzenegger had put up the ballot petitions. And the unions did what they called a special political fight back fund. And we found that in the discovery that they'd called it political fight back, which was really a devastating blow to them. And what they did is they asked the controller of the state of California to take $60 3 times from every state employee in the state to build this political fight back fund. And it literally hundreds of millions of dollars. Mm-hmm. And Diane Knox and 9 of her colleagues in state employment came to us and said, we disagree. We filed a lawsuit back, I guess in 2006 or 7 maybe, right after the ballot initiatives were defeated. That ended up in the U.S. Supreme Court. And what we won there was a really interesting development, and it's a little bit technical, but we won the right for unions to have to require workers to opt in to special assessments and things like this that were outside of the ordinary dues membership structure. So we got the court to look at this opt-in, opt-out question, which we'll get to in a minute because it's a big deal.
Yeah, it is.
So Knox sets up this opt-in, opt-out. Then we argued a case called Harris in 2014 that came out of Illinois, and we were arguing on behalf of a mom, get this, Mark, who was taking care of her own child in her own home. And we had 3 plaintiffs in the case that were forced to pay a fee to the Service Employees International Union to take care of their own kids in their own home because they were participating in a Medicare program that the state had to help take care of children and have people take care of children instead of institutionalizing them, reducing costs by having caretakers that would get a subsidy for this. Mm-hmm, mm-hmm. And so we found out about that. We litigated the case and we won the Harris case. But in the Harris case, the Supreme Court, in a 5-4 ruling, said that these workers were not bona fide state employees, and so they shouldn't be in the structure. But they started talking about this injustice of this forced fees and this speech issue. Mm-hmm. And Alito wrote in his decision something that I think it was in these times, or Mother Jones wrote a story about the case saying, Alito has written a roadmap for the Right to Work Foundation to end forced fees once and for all.
Thank you.
Yeah, well, that was very nice.
Jones?
And we agreed. And so and then the Friedrichs case comes up, and the Friedrichs case out of California. Remember Rebecca Friedrichs case?
Yes.
And she was litigating, basically, that case was being litigated by another organization, but it was litigated on the Harris, on the foundation of Harris, saying that, you can't force these fees. And then, of course, Justice Scalia dies. They argue in January. So he dies in February. The case is remanded back 4-4 with no decision. The good news was we had Janice in the pipeline. Yeah, that's right. And Janice started out as...
folks, they have a lot of arrows in their quiver. Yeah. They don't just take one arrow.
That's right. And we'll report tomorrow at our board meeting here at the Reagan Library. We'll report that we have 285 open cases on behalf of workers all across the country. But getting back to our story. So we have the Janice case, and we argue that case. And on the final day of the... last day of the session, the final case to be decided on June 27th of 2018, the Supreme Court says that it is a fundamental violation of First Amendment rights to compel someone to pay money for speech. We got to the First Amendment. We got exacting scrutiny, or strict scrutiny, if you will, in what was a constitutional question. And so today, no government worker anywhere in America, at the local level, at the county level, at the city level, at the state level, can be compelled to pay dues or fees to a union to keep their job. They can join if they want. They can pay dues if they want. Something you've articulated.
Yeah. It's a voluntary. I mean, unions are supposed to be voluntary associations. If you go back to the earliest, was it 1935?
Yeah, the Wagner Act.
The Wagner Act, and then the Taft-Hartley
in 47.
In 47, and the Congress had the opportunity then to prevent compulsory unionism, but they blinked.
Right.
And they decided, we'll let the states decide whether some states want and some states don't,
Right.
And that created the whole kerfuffle.
Yeah.
That's what we're here for.
Right.
I mean, but now you have, since that day, since 1935, your organizations, plural, has successfely moved now 27 states out of 50.
Yeah, into the right to work column.
Wow.
And we've protected every government employee in America. So there's been a lot of progress recently, but it comes with the kind of the toiling that you know so well. I mean, these aren't easy fights, and it's not easy to go into your union and say, hey, oh, by the way, guys, we want you to have the choice of whether or not you want to join a union. And I don't know how SAG responded to that, but you could probably tell better.
Paul Stewart was a great actor, by the way. He was on the board of directors of SAG with me. And one night he stood up in the boardroom, and this was after we came back from New Mexico.
Okay.
And he pointed his finger at me, and he said, "That is the most dangerous man to ever sit in this boardroom."
Well, just to reinforce that,
I was so happy.
Yeah, Mark. Just to reinforce that, I would ask that it just shows up. You link them to your interview in Idaho, because you understood, you framed the issue so well, you laid it out perfectly, and the interviewer wasn't happy with your remarks because they were unassailable. Right. You just nailed it. So hopefully you'll put that up as a primer.
Well, yeah, but I have to give credit to my writer, who was Shelton Heston. He wrote the script. Chuck wrote the script, and he was off camera. He was coaching me, so I had to do that. Let me ask you this, Mark. Okay, so you've got this trend going. It's right to work is trending. Let me ask you this: two questions. First question is whether or not Janus is applicable to non-governmental employees. What's your ideas about that?
Well, we certainly believe that anytime anybody is forced to do something they don't want to do as a condition of their employment, that's a violation of the First Amendment. But I think the issue for the private sector workers is a little bit more difficult, because what we had in the Janus case is we had state action. We had the state enforcing this compulsion. And so when you have a state action and you have a constitutional question, the state is required to basically to impose this with the least restrictive means possible. And the court said, the government's forcing them to pay dues to keep their jobs. That's not the least restrictive means possible. So that was kind of the understanding of the public sector work, which we thought was a litigation target, starting with Abood, obviously back in 1977. On the private sector side, what happened in the Beck case, and you'll remember this, the labor peace argument was the predominant argument of why this structure had to stand, because if you just freed people from being forced to pay union dues, chaos would break out. And and because
freedom always means chaos. Right?
That's right. Well, they think that these private organizations, a private business and a private union, making these arrangements, I think we need to do a legislative approach to this. Although we don't disregard a litigation solution to it, but the court getting over the hurdle of the court's kind of precedents that have been laid out to this point in the private sector are a little more difficult.
Let me ask you this then. Is there an impulse? I'm sure the answer is probably going to be yes here. I'm sure you guys are working on a legislative solution to this. Now, this would be for a national right to work law.
Indeed, we are, and we have a bill. We have a bill in the U.S. Senate right now. It was introduced back in February. Bill in the U.S. Senate. Senator Rand Paul. Yep. It's Senate Bill 525.
A good libertarian.
Yeah.
Wow, wonderful.
Senate Bill 525, and he introduced that bill. And probably early in the month of May, we'll have a House version of that bill. Joe Wilson from South Carolina will introduce a bill. And Mark, in these days of 2,300-page bills, and where with the Speaker of the House, the current Speaker of the House said you have to pass it to know what's in it. Yeah, the right to work law is
passed, and I still don't know.
Yeah, that's right. No one knows what's in it. Right. Yeah, the right to work law, the right to work bill that's been introduced by Rand Paul and soon by Joe Wilson, is a one-page bill. It does not add a single word to federal law. In fact, we don't, we call it the National Right to Work Law, but it's not a new law at all. We simply go into that 1935 Act that you talked about, the Wagner Act, and we go in and we strike the provisions that authorize compulsory unionism. So while we
in fact, you take words out.
Yes, we take words out. That's right. We don't add a single word. We take words out of the federal code.
I love this.
And that would put the bias of the federal government in favor of voluntarism as opposed to compulsion.
Well, it's supposed to be voluntary.
Yeah. So we have that in the U.S. Senate, and we'll have it in the U.S. House next month, and we'll continue to mobilize on it. Obviously, the prospects of passage are difficult, but as you have learned and you've taught us, just continuing to pound the drum, continue to educate people, continue to mobilize people and identify people that support your position is how you win these battles.
Yes, there are two weapons that I've discovered in my history. I've discovered the same two weapons that you have with your committee, and that is the law courts. That's the biggest weapon that people have to fight for their freedom. And the second one is media.
Yeah, and we're not real good at that, frankly.
No, I think you're very good at that. I think you're very good at that. The coverage on Janice, the coverage on Fredericks was great.
Yeah, fantastic.
In fact, a lot of us were writing letters to our local, newspaper, op-ed pieces and things like that. But no, I thought the Fredericks thing was very, very well handled in terms of that. And the Janice thing was over the top.
It really was, Mark. It was an amazing day. I mean, when you think about mission statements and you think about setting goals for organizations, that's one of those check the box moments without question, freeing every government employee from compulsory unionism.
Yeah, well, I'm not going to be happy until every employee.
Amen.
For instance, I was reading in Middlebury College this morning that there was a professor there who was barred from speaking. And the labor union there that represents the teachers organized some protests against this speaker, who happened to be a conservative speaker, but that's irrelevant. Middlebury had already been in the headlines for violating First Amendment rights. But I realize that there is a difference between a private sector organization who has unionized workers and non-unionized workers, or tries to have compulsion. But if you're successful with the Rand Paul legislation, and I assume you have also co-authors in the House of Representatives.
We do. Yep.
And so I suspect that you probably are not going to get it out of Nancy Pelosi's bailiwick. We may have to wait till 2020 in order to do this, but at least you're setting the stage. You're setting the stage for the run at it.
Yeah. Well, if you look at how the left operates, they know they never give up.
No,
they continue to push.
Two steps forward, one step back. Yeah. 2 steps forward, 1 step back. That's the way the communists took over in the Soviet Union.
Well, I've come across a quote by Winston Churchill that it kind of encourages me, and he said that
one of my favorite quotes.
Yeah, he said, "Success is never final.
Yep.
Defeat is never fatal. It's the courage to continue that counts." And I think Right to Work, since its founding, has been an example, a shining example of that. We've won major battles. We've been beaten a bunch of times, no question about that. But we have the courage to continue, and we have courage because of folks like you and Charlton Heston and the folks we're honoring tonight here in the Reagan Library, and all of our plaintiffs across the country. They have the courage to continue to fight.
Right.
And that's what makes the difference.
Now, I want to bring I'm glad you landed on that particular point, because, so I get a lot of people who question me. I send them on to you, but people come up to me and they say, well, what does exclusive bargaining agent mean? Well, isn't that a good thing for me? Shouldn't we have one union? I know on my campus, by the way, the AFT tried to unionize Santa Barbara City College. This is before I was forced into retirement. But we fought back, and we actually created our own little mom and pop union just to keep the union people happy, right? Because people wanted to have a union. They just wanted to have, they didn't care what the union was. And we showed them what AFT would do if AFT had been our union bosses.
Yeah.
I wanted to ask you, what does a worker do? Who should they contact at your organization? Should they go right to the legal foundation first, or should they go to the committee first?
Well, if they're trying to exercise, they could go to both. But the foundation really is where to get the information about your rights and kind of the fundamental issues of compulsory unionism. And when you talk about exclusive representation, what we need to talk about there, that's the original sin, Mark. I mean, what's happened with exclusive representation is this private organization has been given the privilege to force their representation on you. So you voted no. You didn't ask for the union. You said, I don't want anything to do with the union. I want to be on my own. I want to negotiate my own contract. I think I can do better. The union gets this monopoly bargaining power, and they're now the only voice in the workplace. You can't talk to the boss yourself. If the boss talks to you directly, it's an unfair labor practice. And what happens there is that's kind of the original sin, because then the unions pivot immediately and say, oh my gosh, we have this terrible burden of representing Mark, who voted against us, never wanted us, never asked for us, and would love to negotiate on his own, and we're giving him all this stuff, so he therefore has to pay us. So it's the exclusive bargaining that sets up the framework for compulsory fees. And so going after the exclusive monopoly bargaining is really the next frontier for our work on the litigation front. And we've always been at it on the legislative front as well.
I have an anecdote for you. When I was being forced out of my 23-year position of teaching philosophy at Santa Barbara City College, of course, I had to go through the internal
the grievance process, right?
I mean, folks out there, if you're struggling with a labor union problem and you belong to, let's say, a college or something, there's always going to be these internal grievance things. And ours is a 4-step process, actually 5-step process. And the first step, of course, was for me to go to the labor union.
I got a problem.
Right.
Yep.
So I went to the president of the union and I explained to her. I said, "Here's what we're going to do." And she immediately turns me over to their union attorney,
Okay.
who was in Burbank or someplace like that. He wasn't even in Santa Barbara. And he said to me, "Now, Mark, don't fight this. What you should do is apologize, be nice, and try not to offend anyone." And I rolled my eyes like, "Do you know who you're talking to? Be nice? Don't offend anyone? What are you, crazy?" So I got my own attorney.
Yeah.
My own attorney, very skillfully, I didn't contact you guys because I knew you're busy with other stuff, and I think we could have handled this. We did, actually. Yeah. I got an attorney who actually settled it in 2 months without even filing a court case.
Yeah.
That's how much evidence we had that my First Amendment rights were being violated.
Wow.
Systemically.
Yeah.
I mean, in a systemic way. Yeah. Even the grievance process itself is stacked against you.
That's
the fact
correct.
that you have to go through
Right.
a grievance process.
Yeah. The grievance process is part and parcel of the bargaining arrangement. Okay, so
Right,
the union agrees to this grievance process, and the interesting thing about that, Mark, is you did the first stage, which was go to the union rep and say, "I got a problem."
Right.
At that point, it's now the union representative's discretion to continue that process or reject you.
Right.
And
That's
then you
when
have
I got
no
a
recourse.
lawyer.
Right.
That's when
Yeah.
I got a lawyer because she told me that.
Yeah.
She said, "Well, we may not want to." I said, "Well, why not?"
Yeah.
She said, "Well, several reasons." She actually told
Yeah.
me there were several reasons. First of all, we want to be nice. And we want to negotiate with the Board of Trustees in a nice atmosphere. And our contract is coming up, and we don't want to ruffle any feathers. And secondly, if you were to win some sort of a settlement, why, that means that there won't be any money for us for our merit raises and our pay increases. So we hope you don't get a settlement. We know you've got an attorney now. And she said to me, "I want to tell you, I hope you don't get a settlement."
Yeah.
Can you believe this?
She represents you. No, I'm sorry. Yeah, that's unfair.
She was
unfair.
my exclusive
bargaining agent.
Yeah,
There you go. That's
my
good for you.
monopolistic.
Good for you. You tied up a nice bow on the top of that. Well, and the point is, if let's say that you were able to go through that process and get an agreement from your employer, the school, and it was and it interfered with the contract or conflicted with the contract, the union could veto that settlement because of their exclusive bargaining.
Well, you know what happened? The president. They drove him out after they drove me out. They drove the president out. This guy was rocked in the cradle to be president of this college. No question about it. He was a liberal man. We disagreed. I gave him a book of Marcus Aurelius' Meditations the first day on the job. I said, "You're going to need this.
This will be
someday.
useful.
You're going to need this." And later on, he said, "Yeah." He said, "I'm reading it a lot more now these days." But what they did to him was he saw what the union was doing to me and how they were trying to short circuit it using the grievance process. He waited until we went through all of the 4 previous stages of the grievance, and then it lands on his desk. He was the 5th stage.
Right.
He then went to the Board of Trustees. He said, "Look, there is so much evidence here that if Mark McIntire and his attorney, whose name is Daniel Jett, if they go to a court, they're going to wipe us out. We're going to have to write a large check." And I know Mark doesn't want to damage the college any more than he wants to stay here and be discriminated against because of his views. So let's settle this. So this president went through the Board of Trustees 7-0 in favor of making a settlement, a 6-figure settlement.
Wow.
And I did not even have to sign a confidentiality agreement.
Hence, we're talking about it today.
Right, right. No, I've been yakking.
Oh, you have.
Oh yeah. I've had several interviews. Yeah. You know, the old Hollywood thing is, any ink is good ink. Ink. Guys get a lot of ink. So where do we go from here? We're at 30 minutes into our interview, and I know you want to get into set up for your the Dirksen Award tonight.
Tonight, yep.
And what can you tell us about the Dirksen Award?
Well, Everett Dirksen was a senator from Illinois, and if it hadn't been for him and another senator from Arizona, Paul Fannin, we wouldn't have the ability to pass right-to-work laws. Because in 1965, Lyndon Johnson, whose pictures are on the walls around here.
I saw that.
Yeah, a couple of them anyway, yeah. And Mike Mansfield, the Senate Majority Leader from Montana, decided they wanted to repeal Section 14B of the Taft-Hartley Act. You mentioned that in 1947. Yep. So if they repeal Section 14B, then no state can have a right-to-work law. The federal law would apply to all the states, and the federal law allows compulsion. So Everett Dirksen, it was just after the Civil Rights Act, and there was a lot of polarization in Congress. Imagine that. And so Reed Larson, the president of Right to Work, went to Everett Dirksen, the Senate Minority Leader from Illinois, because the fight over civil rights had kind of consumed everything from the right to work states, and he said, Senator Dirksen, you need to lead the fight on defending 14B. And Dirksen said, you can't win it. You can't win a fight. You can't fight a fight that you can't win. You can't win it. No one's interested. And so Reed walked out. He went out and he got, guess what? Media. He got like 300 newspapers to do editorials about why we should protect 14B. And he went back into Dirksen's office, and Dirksen said, So Dirksen mustered the ability to go fight, and he fought it, and they slowed the U.S. Senate down. In fact, some of the right to work creates so many different interesting kind of anecdotes. And one of the old filibuster, remember Mr. Smith Goes to Washington, you got to take the floor and keep it. And well, Mansfield created what we call the sidetrack now. Dirksen's opposition was so intense that they had to put it on the sidetrack so they could continue to do any business at all in the Senate. And Fannin and a few others stood up and fought that. And so the Dirksen Award is named after Everett Dirksen because he was ultimately the leader of the defense to keep right-to-work laws legal in that 1965-66 battle. So each year we have honored a legislator or someone who has stood up and showed that type of determination fighting for right to work. And Charlton Heston was one of those people. He received the award. In fact, you received the award for him.
He was on stage at the Amundsen Theater doing Detective Story. Otherwise, he would have flown out to Virginia and collected the hardware. But he said, no, I think maybe I should send you out there to collect. And I'm really glad that he did because I got to meet so many wonderful people at the committee and at the foundation. And I don't think I would have been as innovated to stay with right. There were two things that would put Charlton Heston in the saddle. Okay, one of them was guns. All right, gun rights of the individual, and the other one was right to work. It was amazing. He would, if I even slid something across his desk concerning somebody who needed some information, and they were always going to, they were always calling. They're always calling Chuck about two things: guns and right to work.
Wow.
So, what is the immediate future for both the committee and for the foundation?
Yeah, well, obviously on the committee side, we're pushing for the National Right to Work Act. We will just continue to push for that, gain support, gain sponsors, gain attention. On the state side, we're continuing to defend against some anti-Janus workarounds. There's lots of those bubbling up. The unions are trying their darndest to find out ways to work around Janus.
They're very clever.
And continuing to push for right to work laws in the states. On the litigation side, we have actually got a case that will be conferenced at the U.S. Supreme Court on May 9th. A case that attacks the fundamental principle of exclusive representation, a case that comes out of the 8th Circuit on behalf of daycare providers.
Where is the 8th Circuit, by the way?
That's Minnesota.
That's Minnesota.
Up there. Okay. And so that case is pending in front of the court. They will conference to see if they want to argue that case. And what we've got to do is we've got to get four justices to raise their hand saying we'll take the case. Yeah. And if they take the case, Mark, we'll have an oral argument about the freedom of association issue. We got the speech issue. Now we get the association issue.
So does that go into the 14th Amendment?
Well, it goes under the First Amendment certainly.
Well, certainly the First Amendment.
Yeah, Alito mentioned in the Janus decision. He said this forced association is a significant impingement on First Amendment freedoms. Yeah. So we've tried the 14th, we've tried the 5th, we've tried the 1st, we tried the 13th, we've tried them all. And we tried the 13th, and they stick. I mean, the First Amendment now sticks in Janus, and we're getting to try to get it to stick in this case.
Well, it's the strongest of the amendments.
Yeah.
And Chuck used to say the reason why they created the Second Amendment was so that nobody would mess around with the First Amendment.
Right? Yeah.
And I think he's right about that. Yeah. Well, we're here at the Ronald Reagan Library, and museum in Simi Valley, and we're preparing to go into dinner and honor Mr. Reed Larson, right?
Well, we'll honor Reed's always been honored. He's
Okay.
Mr. Right to Work, and we'll
Okay.
honor Tom McClintock, Congressman
Tom
from
McClintock, yeah, yeah.
California tonight.
I know Tom.
Yeah,
But-
he's been a great champion in the state Senate, great champion in Congress.
Yeah,
Right
he's
to
a
Work.
wonderful man.
Yep,
Wonderful man.
and we'll honor a plaintiff out of Oregon who was forced to pay fees that were used to try to defeat her husband, who was running for the state legislative office. She was the first recipient of a total Janus refund after the case. She got all of her money back all the way to statute of limitations, which is very exciting.
Wow.
She's here. We'll honor her courage tonight for fighting for that.
Yeah,
I don't know if my wife would file a lawsuit if they, they would want me defeated. But Deborah stood up for her husband, Mike, who's a state legislator in Oregon, and said, "I will not allow my money to be used to defeat my husband for public office."
Right.
And she won, and we won that case.
Right.
And we've got, I think, almost 30 cases, 28, 29 or 30 cases. It kind of fluctuates based on decisions that we're representing employees in the Janus enforcement area. We've got this Bierman case at the U.S. Supreme Court out of the 8th Circuit. So, as I mentioned earlier, we have 285 open cases in this last quarter. We're defending literally tens of thousands of workers across the country, Mark. And you know the courage it takes to stand up and fight for this. These are extraordinary people. We'll be honoring a few of them tonight, and we're glad to talk about this with you.
Yeah, it's really sad, the psychology that unions use to coerce. I've seen it so many times. I've seen it in the Screen Actors Guild. I've seen it in the academic environment that I've lived in. And what really depresses me, Mark, is the fact that whenever somebody does stand up and take the public position and fights back and pushes back, they always get secret emails and secret letters saying, "I'm with you 100%, but I don't dare do anything because I'm so afraid to lose my job, or I won't get invited to the mayor's cocktail party, or I'll get booted out of the country club," or some such nonsense like that. And you just wonder, how do people get to that point where they won't even stand up for their individual rights?
Yeah, well, that's our job, and thank you for giving us an opportunity to talk about that here and on this show.
We've got a lot more to talk about, but I think we're running out of time. But I do want to thank you, Mark Mix, for doing the job that you're doing. I want to also thank Patrick Simmons, who set this up for us on very short notice. And we're going to try to go in there and maybe even speak to Tom McClintock if he's available, because Tom is a great fighter for these freedoms and for all of our constitutional guarantees. And we'll be seeing you next time. Thank you very much, Mark Mix.
Thank you, Mark.
Tom Mix, we had the opportunity to be at dinner when the award was given for the congressperson, the legislator who has done the most for the right to work movement. And of course, this year is the person I like to call my friend is Tom McClintock, a fellow Californian, and he has received the Everett Dirksen Award this year. Tom, congratulations.
Mark, thank you very much.
And I'm going to ask you to make an appearance on Freedom Matters.
I'm looking forward to it.
Our person in Washington, our man in Washington, Alex Adagio, will contact you. But we really need your work so much. In your acceptance speech, you commented on everybody has the choice to make. You can join a labor union, but you also have the freedom not to join.
In a free society you do, of course. In an authoritarian society you do what you're told. And that's really the only two ways that we organize governments, organize societies. We either organize them as voluntary associations with free individuals making their own choices, leading their own lives, entering into their own voluntary associations with each other for their mutual betterment. And our government simply exists to protect those choices and protect us from those who would deny us the right to make those choices. The other way of organizing a society is authoritarian, where you do what you're told by your betters. And really, every political controversy that I've ever seen down through history comes down to that simple choice: authoritarianism or freedom.
Well, you stand on the side of freedom.
I do.
And God love you, because without your support over the years, the Dirksen Award is given to a person who, over the years, has done day in and day out fighting for individual freedom in the labor market. And Tom McClintock, I can't think of a better person who deserves
It's
this.
very kind of you to say that, Mark. Thank you very much. I'm looking forward to talking with you.
We'll be on the show, either in person or in Skype.
Great.
but you're invited anyway. Thanks a lot, folks. And that's it from the Reagan Library and Museum. Good night.
Mark, tell us your last. Well, say your.
Yeah, Mark McIntire. It's spelled McIntire, and I'm on the Screen Actors Guild Board of Directors.
Hold on one second. Are we? Okay, we're doing fine. Tell us why you support the cause in Idaho.
Well, I think that right to work is very good for labor unions. Most of my colleagues, by the way, disagree with me, and I respect their right of disagreement. But I believe that in every state where right to work has been implemented by the people, by the voters, or by the legislature, it has compelled labor unions to work very hard at the one thing that they should work hard at, namely negotiating the contract. Not electing Walter Mondale or Geraldine Ferraro, but negotiating the contract. Not fighting apartheid in South Africa, but negotiating the contract. Not giving money to Norman Lear and the People for the American Way, but negotiating the contract. If right to work were to come to California, for instance, labor unions would not have the monies to expend on political and ideological causes which many of their members disagree. I certainly disagree with the way they spend my money, my dues monies, on political and ideological causes. And labor unions have been very unsympathetic. They have not listened to our protestations. I'm on the Screen Actors Guild Board of Directors. We go in there every month and we say, please don't spend our dues monies on these things that we dissent for. And they say, get lost. So we're going to get lost. And we're going to work for right to work everywhere in the country.
Yeah, but isn't a union member for a union member? And you're actually saying you're not for, you're for non-union members to work with union members.
No, unionism is a voluntary organization. If a union is such a great thing to belong to, why should you be compelled to join it? You see, and a union shop compels you to join a labor union. People are not compelled to be citizens of the United States of America. They come here voluntarily. Okay, but in the Soviet Union, you're compelled to be, and they put walls up around you. So I think that it's very good for labor unions to compete under a right-to-work environment because it makes them very aggressive. It fine-tunes the one thing they're good at, negotiating the contract. And that's why people pay dues, is to negotiate that contract, not to elect Geraldine Ferraro or Walter Mondale or anybody else, or not to send money to some foreign government, but to negotiate that contract for the workers' interest. And I believe if they concentrate on that, labor union membership would skyrocket. They'd be the hottest ticket in town because they'd be offering a quality service. And that's the key to labor unions' failure right now. They're not offering quality. They're perceived generally as feather bedders, people who escalate the cost of production in my business. And they have to turn away from that. And I think Right to Work will help them to find their proper role in life.
What's going to be happening that Heston is trying to do?
Okay.
Go ahead. Tell us what Charlton Heston is trying to accomplish up there today.
From my understanding, Mr. Heston is trying to bring to the citizens of maintain the right to work already exists in the state of Idaho. He's trying to preserve Idahoanians' right to choose. Right to work is really about right to choose. What Charlton Heston is working for is the ability of citizens of Idaho to choose whether or not they wish to become members of a union. That's all. If you want to become a member of a union, fine, go join. If you don't, you're not forced to. If this referendum is overturned, people would be compelled to join a labor union. Compelled. And compulsion is something that doesn't go down very well in America. As Thomas Jefferson pointed out, he who is compelled to contribute monies to political causes with which he disagrees is asking to contribute to something that is both sinful and immoral.
But aren't you doing the opposite? I mean, you want non-union people who can get lower wages working with union people, and soon, wouldn't that kick out the union eventually?
Not necessarily. The Idaho Statesman, for 28 years, opposed right to work. For 28 years. They're a very Democrat, very liberal publication. Last month, they came out in favor of right to work editorially, and it made, as you can understand, made history in the state of Idaho. And what did they say? They said anything that makes the cash registers work and ring in the state of Idaho is good collectively for all the citizens of Idaho, those who wish to join unions and those who do not wish to join unions. So more jobs an improved economy is going to ultimately improve the situation of union members. And the AFL-CIO statistics prove that. If you look at what the AFL-CIO has published in every right-to-work state, there have been more jobs, better benefits, better wages, both for union people and for non-union people. It stimulates the economy. It's basic economics. Instead of driving away production, it stimulates production. And that's basically what the issue is about, the freedom to choose. A person should not be compelled to join an association that they don't wish to join. It's as simple as that.
Why did you join?
I had to. In order to be an actor, I was compelled to join the Screen Actors. You know, it always bothered me. I said to myself, wait a minute, I can't work as an actor in this town unless I join the Screen Actors Guild? I was always very disturbed about that. And I never understood why, legally and technically why, until after I became involved and ran for the board of directors and was elected to the board of directors. You know, I'm on trial tomorrow for writing a memorandum concerning right to work. I'm on trial. The Screen Actors Guild board of directors has set up a trial committee to investigate my writing a memorandum to my fellow board members, which explains the rights of dissidents within the labor union. And we go on trial at 5 o'clock tomorrow.
What's the trial going to be based on? The memorandum and...
Apparently so. Apparently I'm being put on trial because I wrote a memo which talked about the rights of dissidents within a labor union. Yes, that's exactly what I'm being put on trial for.
So you could get ousted from it?
I could be kicked off the board, and ultimately I could be thrown out of the Screen Actors Guild. Exactly.
For telling or saying your rights or writing your rights?
For communicating legal facts to other members of the union who have requested that I communicate those legal facts. Exactly. Exactly.
What did you say that brought up the trial?
I referred to various court cases which prove, beyond any shadow of legal doubt, that those members of the Screen Actors Guild who dissent from the way monies are being spent for political and ideological causes may opt to become what is called financial core members of the Screen Actors Guild, or Buckley members, after William F. Buckley, who refused to join AFTRA in order to do his program firing line. And he took it all the way to the Supreme Court, and they upheld his right to not join the labor union. He is not a member of the labor union. He doesn't have to join the labor union. And I just explained this to other members of the board who had asked me to get the legal research done, which I did. And that's what I'm being tried for. The union is terrified of this information, because if enough people understand the information contained in my memo, they would see that they have a parachute to escape from compulsory union expenditures of their dues monies for political causes with which they disagree. It's a parachute, and the union is terrified, which explains why they're taking irrational steps to discipline me.